So then now we come to the final criterion, and this is where was Bradley Pike's personal and economics relations the closest? Was it with Thailand, was it with Australia, or was it with both? And the primary judge said, on the evidence, Mr. Pike undoubtedly had a range of personal relations while he resided in Thailand. So this comes back to him being a very sociable guy, right? He formed particular friendships and actively engaged in various sporting and social activities in Thailand. As Ms. Thornycroft neatly put it, he had a life there. He was hardly there a mere fly-in, fly-in-out worker eating and sleeping at work camp with no wider community life. However, at an emotional life, his closer personal relations were undoubtedly with Mrs. Thornycroft and their sons in Australia. In contrast, overwhelmingly, Mr. Pike's economic relations were closer to Thailand. So the judge makes a difference. He says, personal relations, very clearly Australia, right? Even though he has friends and everything in Thailand, family is in Australia. But then if you look at economic relations, it really is Thailand. And the judge goes on to say, for the part of the period between 2010 and 13, Mr. Pike owned a capital asset in Australia, the Brookwater land, where they were going to build the house on the golf estate. And while I can accept this land can, on the basis of ownership alone, be regarded as evidence of an economic relationship with Australia, it did not have the additional feature of being a comparative or any sort with the Thai employment for income production. So clearly the economic relations with Thailand were by far the stronger. And then he also says Mr. Pike jointly owned cars in Australia, but even in conjunction with the Brookwater land and as foundation for relative closeness of economic relations, these pale into relative insignificance when compared to Mr. Pike's Thai employment. So really the economic relationships were in Thailand. And the judge goes on to say Article 4, Clause 4 makes nationality a factor, but until almost the end of the period in question, Mr. Pike's nationality was Zimbabwean. And this is what's nice about this case, right? I mean, very often authorities get to escape to citizenship to decide a tiebreaker, but here they couldn't because he wasn't a citizen of either. He only became a citizen of Australia, as the judge says here, in April 2014. But what the judge to me seems to do is he says, the fact that he held on to his Zimbabwean citizenship so long rather is a sign of more disengagement from Australia than that the fact that he got the citizenship in Australia in 2014 was a sign of engagement, right? So the judge says, if anything, Mr. Pike's Zimbabwean citizenship for most of the period in question rather emphasizes the importance relative to his Australian connection of his personal and economic ties with Thailand. And I think what the judge is trying to say is if this guy really had such a strong personal and economic tie with Australia, he would have become a Australian citizen much quicker together with his wife and his sons. But he didn't. He only became an Australian citizen once it became difficult to get into Australia and to travel elsewhere without being the Australian citizen, right? But and that probably was because of an emotional tie with Zimbabwe, where he still had family living and everything. So the primary judge concluded, in my view, when considered conjunctively, so you look at both economic and personal relations, Mr. Pike's personal and economic relations were closer to Thailand than to Australia, because he had personal relations in both, but he really only had economic relations in Thailand. And then the federal court needs to decide this point as well, and they say that leaves the question of personal and economic relations. And further down the paragraph they say the commissioner accepted that the primary judge correctly observed that Mr. Pike's personal and economic relations had to be considered conjunctively. And again, this is to me an interesting new concept, right? That you look at the personal and economic relationships not as one basket, but you look at them conjunctively, but you in any case do not look at them separately, right? And then the commissioner said, the judge said that he looked at them together, but he actually looked at them separately, right? Because the paragraph goes on to say, however, it was submitted by the commissioner in applying the test, the judge fell into the error by applying the test disjunctively. As we can see here, the judge talked about personal relations, and then he talked about economic relations. And the Commissioner goes on to say it was argued that the primary judge considered first Mr. Pike's personal relations were closer to Australia or Thailand, and secondly, as a separate and independent consideration, whether Mr. Pike's economic relations were closer to Australia and Thailand. And somehow the Commissioner must argue that if he's done the economic and personal relations together, he would have come to the conclusion that those were closer to Australia rather than to Thailand. But the Court of Appeal does nothing with that. They say, we reject both the contention that the primary judge applied a disjunctive test and the contention that the finding of facts should have led to the primary judge to conclude that Mr. Pike's personal and economic relations were close to Australia. First, no error is discernible in the approach of the primary judge in examining Mr. Pike's personal and economic relations. Each case must be fact-specific. In some cases, the personal and economic considerations may be quite separate and distinct matters, and that's why the judge considered them distinctly, not because he applied a disjunctive approach. And then the court says, secondly, and then further down the paragraph, the Commissioner's case in substance rested on the weight which the primary judge attributed to some of the facts. So it's not that he's done it wrong. The Commissioners say that he must have weighed them differently, and the court comes and says this is wrong. Third, an evaluation of the facts does not persuade us that the conclusion of the primary judge was wrong. And here comes the part that I really respect the appeal court for, because it says an appeal court will not overturn the decision of a primary judge merely because it prefers an outcome different from that adopted by the primary judge, where both outcomes are equally available and finely balanced. In our view, this is such a case as the findings of fact upon which the Commissioner rested his case do not compel a different conclusion. And what the Court of Appeal says here is, we need to look at whether the primary judge made a judgment in law or severely misweighed the facts. But if it's nuanced, we can't overturn the primary judgment just because we think it should be different, but it's an emotional rather than a legal decision. So all in all, I think this has been a very interesting, very balanced case. The court concluded we would dismiss the appeal and cross appeal. In other words, the primary judge's decision that Mr. Pike was resident of Thailand and not Australia under Article 4.3 stands. What the case does not address, because it can't, is what about Tanzania and the UAE? Australia does not have treaties with Tanzania and the UAE. The case was very clearly that under Australian law, even though Mr. Pike spent much less than 183 days in Australia, he was a resident of Australia for all these years. The Thai-Australian treaty saved him from being taxed as a resident because he already paid tax as a resident in Thailand. He also paid tax as a resident in Tanzania and UAE, as far as we know. So does he now pay double tax? And the answer is yes. Australia did give credit for some taxes in 15 and 16. If you go back and look at the table that I showed in the initial slides, but that was for $10,000 and for $6,000. And if you look at the amounts of money that Mr. Pike remitted to Australia, he clearly earned good money because he transferred hundreds of thousands of dollars to Australia, right, from salary. So he's done well in that respect, and one would wonder if a credit then for Tanzania for $10,000 and $6,000 would be enough. I mean, in Tanzania at the time, as I understand it, the tax rate for residents was up to 30%. And for non-residents, it was a flat rate of 15%. But in both cases, I mean, that is $10,000 in tax or $6,000 would not cut that if Mr. Pike declared his full income in Tanzania and in the UAE. Which the court believes tells us that he has done. So interesting case. At least he got saved from double tax for the bulk of the period when he was working from Thailand, but it doesn't solve his cases for Tanzania and the UAE. And finally, again, I find it strange because he spent less than 183 days in Australia. Hope you enjoyed the case as well, and I look forward to discussing our next case with you during one of the next weeks. Bye for now.